Title 8, Crimes Against Persons, Section 1, Parricide, Murder, and Homicide. Article 246, Parricide, that a person is killed. Second is that the deceased is killed by the accused. And third, that the deceased is the father, mother, or child, whether legitimate or illegitimate, or a legitimate other ascendant or other descendant, or the legitimate spouse of the accused. Cases of parricide when the penalty shall not be reclusion perpetua to death. Parricide through negligence, Article 365. Parricide by mistake, Article 249. Parricide under exceptional circumstances under Article 247. The child should not be less than 3 days old, otherwise the crime is infanticide, Article 255. Article 247, death or physical injuries inflicted under exceptional circumstances. First, that a legally married person or a parent surprises his spouse or his daughter, the latter under 18 years of age, and living with him in the act of committing sexual intercourse with another person. Second, that he or she kills any or both of them or inflicts upon any or both of them any serious physical injury in the act or immediately thereafter. And third, that he has not promoted or facilitated the prostitution of his wife or daughter, or that he or she has not consented to the infidelity of others. Article 248, Murder. Murder, unlawful killing of any person which is not parricide or infanticide, provided that any of the following circumstances is present. First, with treachery, taking advantage of superior strength with the aid of armed men, or employs means to weaken the defense or of means or persons to ensure or afford impunity. Second, in consideration of a price, reward, or promise. Third, by means of inundation, fire, poison, shipwreck, stranding of a vessel, derailment or assault upon a railroad, fall of an airship by means of motor vehicles, or with the use of any other means involving great waste and ruin. Fourth, on occasion of any calamities enumerated in the preceding paragraph, of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity. Fifth, with evident premeditation, or sixth, with cruelty by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse, as amended by RA number 7659. Elements: first, that a person was killed. Second, that the accused killed him. Third, that the killing was attended by any of the qualifying circumstances mentioned in Article 248. And fourth, that the killing is not parricide or infanticide. Rules for the application of the circumstances which qualify the killing to murder. First, that murder will exist with only one of the circumstances described in Article 248. Second, where there are more than one qualifying circumstances present, only one will qualify the killing, with the risk of to be considered as generic aggravating circumstances. Third, that when the other circumstances are absorbed or included in one qualifying circumstance, they cannot be considered as generic aggravating. Fourth, that any of the qualifying circumstances enumerated in Article 248 must be alleged in the Article 249 homicide. Elements: that first, that a person was killed. Second, that the accused killed him without any justifying circumstance. Third, that the accused had the intention to kill, which is presumed. And fourth, that the killing was not attended by any of the qualifying circumstances or murder by that of parricide or infanticide. Section 1, Parricide, Murder, or Homicide. Article 250. Penalty for frustrated parricide, murder, or homicide. Courts may impose a penalty through 2 degrees lower for frustrated parricide, murder, or homicide. Courts may impose a penalty 3 degrees lower for attempted parricide, murder, or homicide. This provision is permissive, not mandatory. Article 251. Death caused in a tumultuous affray. First, that there be several persons, that they did not compose groups organized for the common purpose of assaulting and tracking each other reciprocally. Otherwise, they may be held liable as co-conspirators. Third, that these several persons quarreled and assaulted one another in a confused and tumultuous manner. Fourth, that someone was killed in the course of the affray. Fifth, that it cannot be ascertained who actually killed the deceased. And sixth, that a person or persons who inflicted serious physical injuries or who used violence can be identified. Persons liable. First is the person or persons who inflicted the serious physical injuries are liable. Second, if it is not known who inflicted the serious physical injuries on the deceased. All the persons who use violence upon the person of the victim are liable, but with lesser liability. Article 252. Physical injuries inflicted in a tumultuous affray. First, that there is a tumultuous affray as referred to in Article 251. Second, that a participant or some participants thereof suffer serious physical injuries or physical injuries of a least serious nature only. Third, that the person responsible therefore cannot be identified. And fourth, that all those who appear to have used violence upon the person of the offended party are known. Article 253. Giving assistance to suicide. Acts punished first by assisting another to commit suicide, whether the suicide is consummated or not. Second, by lending his assistance to another to commit suicide to the extent of doing the killing himself. Article 254. Discharge of firearms. First, that the offender discharges a firearm against or at another person's, and second, that the offender has no intention to kill that person. Section 2. Infanticide and abortion. Article 255. Infanticide. Elements that first, that a child was killed. Second, that the deceased child was less than 3 days or 74 hours of age. And third, that the accused killed the said child. Person liable in intentional abortion. First, the person who intentionally caused the abortion under Article 256. Second, the pregnant woman if she consented under Article 258. Article 256. Intentional abortion. Ways of committing intentional abortion. First, by using any violence upon the person of the pregnant woman. Second, by acting without using violence and without the consent of the women, by administering drugs or beverage upon such pregnant women without her consent. And third, by acting with the consent of the pregnant women, by administering drugs or beverage. Elements that there is a pregnant woman. Second, that violence is exerted or drugs or beverage administered or that the accused otherwise acts upon such pregnant women. Third, that as a result of the use of violence or drugs or beverage upon her or any other act of the accused, the fetus dies either in the womb or after having been expelled therefrom. And fourth, that the abortion is intended. Section 2. Infanticide and abortion. Article 257. Unintentional abortion. First, that there is a pregnant woman. Second, that violence is used upon such pregnant women without intending an abortion. Third, that the violence is intentionally exerted. And fourth, that as a result of the violence, the fetus dies either in the womb or after having been expelled therefrom. Article 258. Abortion practiced by the woman herself or her parents. First, that there is a pregnant woman who has suffered an abortion. Second, that the abortion is intended. And third, that the abortion is caused by if the pregnant woman herself, B, any other person with her consent, or C, any of her parents with her consent for the purpose of concealing her dishonor. Article 259, abortion practiced by a physician or midwife in dispensing of abortive elements. First, that there is a pregnant woman who has suffered an abortion. Second, that the abortion is intended. Third, that the offender, who must be a physician or midwife, causes or assists in causing the abortion. And fourth, that said physician or midwife takes advantage of his or her scientific knowledge or skill. As to pharmacists, the elements are: first, that the offender is a pharmacist; second, that there is no proper prescription from a physician; and third, that the offender dispenses any abortive. Section 3, Dowell. Article 260, responsibility or of participants in a duel acts punish: first, by killing one's adversary in a duel; second, by inflicting upon such adversary physical injuries; and third, by making a combat although no physical injuries have been inflicted. Persons liable: first, the person who killed or inflicted physical injuries upon his adversary or both combatants in any other cases as principals; second, the seconds as accomplices. Article 261, challenging to a duel. Acts punish first, by challenging another to a duel; second, by inciting another to give or accept a challenge to a duel; and third, by scoffing or decrying another publicly for having refused to accept a challenge to fight a duel. Persons liable: first, challenger; second, investigators. Article 262, mutilation, two kinds. First, by intentionally mutilating another by depriving him, either totally or partially, of some essential organ for reproduction, castration. Elements: that there be castration, that is, mutilation or organs necessary for generation, such as penis or ovarium; and b, that the mutilation is caused purposely and deliberately, that is, to deprive the offended party of some essential organ for reproduction; 2, by intentionally making other mutilation, that is, by lopping or clipping off any part of the body of the offended party, other than the essential organ for reproduction, to deprive him of that part of the body. Article 263, serious physical injuries. How committed: first, by wounding; second, by beating; third, by assaulting; or fourth, by administering injurious substance. Serious physical injuries: first, when the injured person becomes insane, imbecile, impotent, or blind in consequence of the physical injuries inflicted; second, when the injured person a, loses the use of speech or the power to hear or to smell, or loses an eye, a hand, a foot, an arm, or a leg; b, loses the use of any such member; or c, becomes incapacitated for the work in which he was therefore habitually engaged in consequence for the physical injuries inflicted; 3, when the person injured a, becomes deformed; 3, when the loses any other member of his body; or c, loses the use thereof; d, becomes ill or incapacitated for the performance of the work in which he was habitually engaged for more than 90 days in consequence of the physical injuries inflicted; 4, when the injured person becomes ill or incapacitated for labor for more than 30 days, but must not be more than 90 days, as a result of the physical injuries inflicted. Requisites of deformity: first, physical ugliness; second, permanent and definite abnormality; and third, must be conspicuous and visible. Qualifying circumstances: first, offense committed against person enumerated in the crime or parricide; second, with the attendance of circumstance which qualify the crime to murder. Article 264, administering injurious substance or beverage. First, that the offender inflicted upon another or any serious physical injury. Second, that it was that the offender inflicted upon another any serious physical injury. Second, that it was done by knowingly administering to him any injurious substances or beverages, or by taking advantage of his weakness or mind or credulity. And third, that he had no intent to kill. Article 265 lists serious physical injuries. First, the offended party is incapacitated for labor for 10 days or more but not more than 30 days, or needs attendance for the same period. And second, the physical injuries must not be those described in the preceding articles. Qualified list serious physical injuries. First, a fine not exceeding 500 pesos in addition to arresto mayor shall be imposed for less serious physical injuries when E. There is a manifest intent to insult or offend the injured person, or B. There are circumstances adding ignominy to the offense. Second, a higher penalty is imposed when the victim is either E. the offender's parent, ascendant, guardian, corrector, or teacher, or B. persons of rank and persons in authority, provided the crime is not direct assault. The law includes two subdivisions to it. First, the inability for work, and second, the necessity for medical attendance. Article 266, slight physical injuries and maltreatment kinds. First, physical injury which incapacitated the offended party from 1 to 9 days or required medical attendance during the same period. Second, physical injuries which did not prevent the offended party from engaging in his habitual work or which did not require medical attendance. And third, ill treatment of another by deed without causing any injury. Anti-hazing law RA number 8049. Hazing is an initiation right or practice as a prerequisite for admission into membership in a fraternity, sorority, or organization by placing the recruit, neophyte, or applicant in some embarrassing or humiliating situations, such as otherwise subjecting him to physical or psychological suffering or injury. Acts are punishable, all acts, so long as it causes physical injuries at very least. Persons liable: first, officers and members of the fraternity, sorority, or organization who actually participated in the infliction of physical harm shall be liable as principals of if the person subjected to hazing suffers any physical injury or dies as a result thereof. Second, owner of the place where the hazing is conducted shall be liable as an accomplice when he has actual knowledge of the hazing conducted therein, but failed to take any action to prevent the same from occurring. Third, parents shall be liable as principals when they have actual knowledge of the hazing conducted in the home of one of the officers or members of the fraternity, sorority, or organization, but failed to prevent the same. Fourth, school authorities and facility members shall be liable as accomplices when they consent to the hazing or have actual knowledge thereof, but failed to take any action to prevent the same from occurring. Fifth, the officers, former officers, or alumni of the organization, group, fraternity, or sorority shall be liable as principals if they actually planned the hazing, although not present when the acts constituting the hazing were committed. 6. Officers or members of the organization, group, fraternity, or sorority shall be liable as principals if they knowingly cooperated in carrying out the hazing by inducing the victim to be present thereat. 7. The fraternity or sorority's advisor shall be liable as principal if he was present when the acts constituting the hazing were committed and failed to take any action to prevent the same. Chapter 3, Rape. Article 266 and A, Anti-Rape Law. Classification of rape. First, traditional rape under Article 335, carnal knowledge with a woman against her will. In this case, the offender is always a man and the offended party is always a woman. Second, sexual assault under RA 8353. This is committed when the offender inserts his penis to another person's mouth or anal orifice, or by inserting an instrument or subject into the genital or anal orifice of another person. The offender can either be a man or a woman in the case of the insertion of any instrument or object. How rape is committed? First, by a man who shall have carnal knowledge of a woman under the following circumstances: A. Through force, threat, or intimidation. B. When the offended party is deprived of reason or otherwise unconscious. C. By means of fraudulent machinations or grave abuse of authority. D. When the offended party is under 12 years of age or is demented, even though none of the circumstances mentioned above be present. Elements: E. That the offender is a man. B. That the offender had carnal knowledge of a woman. C. That such as accomplice under any of the following circumstances: by using force or intimidation, or when the woman is deprived of or otherwise unconscious, or by means of fraudulent machination or grave abuse of authority, or when the woman is under 12 years of age, demented. Second, by any person who under any of the circumstances mentioned in paragraph 1 hereof shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice of another person, or any instrument or object into the genital or anal orifice of another person. Article 266b, Qualified Rape. Rape under both acts of committing it is qualified by the following. Note: rape is punishable by death if it falls under any of 4 to 14 circumstances. First, when rape is committed with the use of a deadly weapon or by 2 or more persons. Second, when the reason or occasion of rape, the victim has become insane. Third, when the rape is attempted and a homicide is committed by reason of or on the occasion of rape, special complex crime. Fourth, when by reason of or on occasion of rape, homicide is committed, special complex crime. Fifth, when the victim is under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim. 6. When the victim is under the custody of the police or military authorities or any law enforcement or penal institution. 7. When the rape is committed in full view of the spouse, parent, or any of the children or other relatives within the third civil degree of consanguinity. 8. When the victim is religious, engaged in legitimate religious vocation or calling, and is personally known to be such by the offender before or at the time of the commission of the crime. 9. When the victim is a child below 7 years old. 10. When the offender knows that he is afflicted with HIV or AIDS or any other sexually transmissible disease, and the virus or disease is transmitted to the victim. 11. When committed by any member of the AFP or paramilitary units thereof, of the PNP or any law enforcement agency or penal institution, when the offender took advantage of his position to facilitate the commission of the crime. 12. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability